So let's talk about our final category of trusts, which are resulting trusts. Now, when we talk about the mistaken payment that Mary makes to John, that is also a type of resulting trust. And it's a constructive trust because she didn't mean to create a trust. She didn't mean to give away the money to John. It's an automatic resulting trust because Mary gives away the legal title to the 500,000 shillings, but she keeps, or the court gives back to her, or presumes that she has back, presumes is a bad word, gives back to her that equitable interest. She keeps it. And a resulting trust is apparently comes from a Latin word that means to jump back, but what it means is that the settlor either retains or gets back that equitable interest even if they don't get back the legal interest. For a mistaken payment, that is a type of automatic resulting trust, and so it's a constructive trust. A presumed resulting trust is where essentially a court or the law says that this was very likely done as an expression of trust, or it was meant to be a trust, and so we're going to say that it was a trust. In very, very basic terms, that's what a presumed resulting trust is. And so that is actually, according to Swadling's analysis, a creature of express trust, and an automatic resulting trust is a creature of constructive trust. And you'll see I've put that on the diagram. To my memory, not every textbook agrees with that analysis, and some of them have resulting trust as their own category. So if you're reading something and it doesn't quite adhere to that idea, it might not be you, it might be the academic writing the textbook has a different way of analysing resulting trusts. And again, if you're coming across that and it's confusing you, let me know and I'll see if I can get hold of a copy of the textbook or write down what it is that's confusing you and I can have a look. So mistaken payment is an idea of, is a concept in automatic resulting trusts. So let's talk about a presumed resulting trust. So let's say Bob and Sally buy a house. Now, importantly, Bob and Sally aren't a couple and this isn't going to be their family home. It's going to be an investment because family homes have different rules. So let's say Mary sells the house. She's a good trustee. She does everything right. She sells the house because it's no longer making enough money in rent, and she reinvests the proceeds in stocks and shares. She can do that. She's a trustee. She acts in her mother's best interest. She gives her mother the proceeds of sale, whatever. Mary no longer has the house in this scenario. It's bought by Bob and Sally. But let's say actually only Sally buys the house. It's her name that goes down in the UK to own a house. It's the name that goes down at the land registry as the official owner. So Sally's the only one down at the land registry, but Bob gave her half of the purchase price. Now it's presumed that, so let's say half of the purchase price was 6 million shillings. And so Bob gives Sally the 6 million shillings, and it's presumed that he didn't do that as a gift. If it's payback for a loan or something, then there's no presumption of a resulting trust. But if there's no evidence or there's no reason other than a gift why Bob would have given the money to Sally, then it's presumed that Sally is holding half of the property on trust for Bob. Now, Sally can, if Bob says Sally has the legal ownership but she needs to administer half of the house for my benefit, Sally can say, actually no Bob, it was a gift and I don't owe you anything, and she can rebut the presumption that there is a resulting trust here. You'll have read also about ways to flip that presumption. One of those is the presumption of advancement. The presumption of advancement is a really funny thing to get your head around. Basically, going back to the days when equity was separate, there used to be a system in the UK, you may have come across it in your other reading, called primogeniture. And this meant that for the wealthy, only the firstborn son inherits all of the land and all of the property, or a big chunk of all of the land and all of the property. And it meant that A, the younger son's got nothing, and B, the older son doesn't get anything until the father dies. It was a weird system, but it endured for centuries. If there were only daughters, then everything gets split equally amongst the daughters. So the presumption of advancement comes from the idea that it was a father's moral duty within his lifetime to start giving his property away, either to give his older son enough to live on while his father was still alive, or to set his sons up in a proper career, or buy them land, or buy them investments. So in the thinking of the law, it's perfectly natural that a father would just give property away, give large chunks of money away. And that creates a presumption of advancement, advancing money to the next generation before the older generation is dead. So advancing the money ahead of the inheritance. And the presumption of advancement means that if today a father and presumably a mother just gives money to their child, it's presumed that that is a gift, and it's on the parent to say, no, it wasn't a gift, and in fact that my child is holding the property on resulting trust for me. So if Bob was actually Sally's father, Sally doesn't have to prove that the money was a gift. It's assumed it was a gift, and Bob has to prove that the money wasn't a gift. And there is a resulting trust here. Really hard to get your head around, so I hope that made sense. Let me know if you want me to go over it again. There's another type of there's another type of presumed resulting trust, and that's a failed express trust. Again, I've put it on the express trust side of the diagram. And for an example, that would be if, let's say, Mary didn't sell the house. Let's go back to our previous scenario. John gave the house to Mary for her mother's lifetime as trustee, and didn't specify what would happen if and when Jane dies. So when Jane dies, it is presumed that Mary is holding the property on trust for the settler. So that equitable interest that Jane was holding, that John gave away, it goes back to John. So it springs back to John, and that's where the idea of a resulting trust comes from. And again, that's the presumption that the law makes. So another word is just that's what the law assumes is going to happen. And perhaps Mary has evidence to say, actually, John meant for me to have the full benefit of the house after my mother's lifetime. And so she can try and rebut that presumption. But that's a resulting trust.